Right, well, I think we will make a start. We've now got a good number, and obviously other people will join, but we will start the proceedings. Good morning, everybody, and thank you for participating in this webinar, and thank you also to people who submitted information in advance. That's all been helpful to us in thinking about what we wanted to talk about, which might be of some use. Just in terms of how we are planning things, we have got a brief overview of what we were going to talk about this morning. We were going to talk about, first of all, the duty to cooperate, because that provides the context to thinking about more strategic planning. Then we're going to talk about those cases where joint working has been tried, but problems have arisen. We're going to contrast that with those cases where joint working has successfully produced a useful development plan outcome. We're going to touch on the importance of the statement of common ground. Then we had included in the slides the possibility that we might say something about the planning policy paper, but as you know, it doesn't yet exist. So that we will move on to quickly, and then we will come to our Q&A session. So starting off with the duty to cooperate, and obviously you're not just going to hear from me, you're also going to hear from Dr. Ashley Bowes, who you can see, I think, on your screens, and we're going to cox and box around the various topics, so you'll hear from both of us. The duty to cooperate clearly has been with us since the Localism Act 2011, but it's perhaps just worth a recap on the position that we previously had. Obviously, we had the era of the structure plan, which did involve planning across local authority lines through a structure plan, setting out the position for a strategic scale of administrative planning, with district councils operating under the umbrella of that strategic scale unit. As you will know, it involved external scrutiny, both because there were the things called government offices, which sort of policed the system, but there was also then the examination in public with either an inspector or a panel of inspectors to test the adequacy of the strategic plan. And sitting above the structure plans was the non-statutory guidance that was issued initially simply by the various secretaries of state in terms of regional guidance, but then they, as it were, the non-statutory regional bodies such as Surplan providing their guidance to then inform the structure plans. Obviously, some people thought that that system worked reasonably well, but there were other concerns that the structure plan as a unit wasn't large enough to grapple with strategic issues, and there were other concerns of people feeling somewhat disenfranchised from the process of top-down planning. We then moved to the regional plan. I've called it the modern age because it was seen to be a more forward-looking way of building on the previous structures, removing the structure plans, which were seen as something of a break to development, possibly because the then government in power saw the Tory shires as the blockers, and we had the regional plans put in place. It could be seen as a logical next step of formalising the structures, but practice seemed to show that it wasn't wildly popular. There were difficulties with disengagement. There was very much a feeling that it was a top-down process, and so obviously the coalition government came in with its reform built on the principle of localism, and removing regional planning, not going back to structure planning, and so effectively making the district or the unitary authority the master of its own destiny, but recognising that there were larger than local issues that would need to be grappled with, introducing Section 33A and the duty to cooperate as a means of trying to grapple with those bigger issues. We know, and we're not going to discuss the terms of the duty and what it requires in terms of any details. You'll all be familiar with that if you are plan making or if you are participating in plan making as a promoter of sites. The courts have looked at the duty to cooperate on a number of occasions, and essentially I think it can be summarised as a hands-off approach, that they recognise that it's very much a judgment laden duty. So I think there were some initial cases as to what does it bite on, and it bites at a plan in preparation, not after preparation. But then the Zurich case from 2014 made the point that it's a duty to cooperate, not a duty to agree, which is still the case and worth stressing. The Barker Mill case from 2015 very much emphasised the importance of the respect for the planning judgments which are embedded in the way that the duty is worded, so not really amenable to challenge in the courts, and drawing a distinction between the planning judgments which rest with the local planning authority in the first instance, and then the planning judgments made by the inspector on the discharge of the duty. Examples of, in a sense, that working through in practice, Central Beds back in 2015, there the relevant inspector adopted what you could say was a very rigorous approach to whether Central Beds had adequately discharged the duty in terms of addressing the unmet needs of their neighbour Luton. Central Beds effectively complained through the High Court about what the inspector had done by finding that they'd not met their duty, but the court said no, that was, you know, a legitimate exercise by the inspector of his planning judgment, having looked at the facts and heard the various arguments. St Albans from 2017 is a similar case in that sense, where the inspector wasn't satisfied that the local authority had adequately discharged the duty. The important points that come out of that was that effectively they saying, well, it's not a duty to agree, and we were never going to agree with our neighbours about unmet housing needs. So what was the point? That was their argument. But the courts supported the inspector, who said that, you know, the issue is it's an ongoing duty. It applies throughout the preparation of the plan up to the point of submission. And even in cases of apparent disagreement, it's not good enough, as it were, to give up. You've got to carry on working through constructively to see whether or not engagement can produce a solution to apparently intractable problems. And again, the court said those were legitimate planning judgments for the inspector. Also, as in a sense, a sidewind point that comes out of St Albans is it's not a case of saying, well, we've cooperated on lots of things and we've reached agreement on lots of things, so we must have discharged the duty, i.e. in a sense looking at the quantum rather than looking at the quality of what's happened, and the court saying no, if you fail to engage and fail to cooperate on a particular issue, you're not going to be redeemed by the fact that you might have had oodles of cooperation on the non-contentious issues. Then we come to the challenging inspector, which is effectively the corollary of the fact that it's a hands-off approach by the courts. There is certainly in recent sort of decisions from PINS, more and more of a challenging approach being taken by inspectors. I think a few years back, inspectors, not quite, but a large number of them were saying, well, if none of the duty to cooperate partners are moaning, we're not going to really get too involved. But that certainly doesn't seem to be the more recent experience. St Albans features again, as it were. Here you've got the situation of the treatment of Greenbelt as an issue, in terms of St Albans proposing to release land from the Greenbelt to meet their housing needs, and the inspectors being concerned that they hadn't properly tested whether or not any of their neighbours could meet their needs, together with something of a St Albans specific position, which is the Strategic Rail Freight Interchange at Radlett, which has been granted permission as an interchange, but which St Albans in their proposed plan were proposing for housing. And the inspector was saying, well, you haven't really thought about where that would go if it's not happening on that site, and you haven't engaged with your neighbours about whether it can be displaced elsewhere. See, that battle is still ongoing, with St Albans coming back, as it were, to the inspectors and saying, look, first of all, so far as the rail freight is concerned, we'll drop that proposal, and that's really a soundness issue, not a DTC issue. That's what they're arguing. And on the Greenbelt unmet needs issue, they're saying come off it. In the real world, the duty doesn't require you to ask sort of questions to which you already know the answers. And it's quite obvious that none of our neighbours is going to be able to accommodate our unmet needs, which is why we've had to look at our Greenbelt. It will be interesting to see how that plays out with the inspectors. There are some echoes if you go back to Barker Mill, where there the question was affordable housing, and part of the challenge was that Tess Valley, which was the local authority in that case, hadn't asked their neighbours expressly, we can't meet all of our affordable housing needs, can you help out? And that was sought to be brought as a point of challenge, but the court said no, it was perfectly legitimate that they didn't need to ask that question, because it was blindingly obvious from all the work they'd already done what the answer was, that they couldn't meet their affordable housing needs, and nor could their neighbours. So the prospect that their neighbours would be able to pick up their unmet affordable housing needs was effectively for the birds and didn't need to be asked. Then Wealden is an example of an authority failing to engage with unmet needs, particularly the unmet needs from Eastbourne. Sevenoaks, I'll come back to Sevenoaks. So South Bucks and Chiltern, it's pending, because that's obviously only interim findings from the inspector. But there again, it's unmet needs, this case unmet needs from Slough, not being addressed adequately through the duty to cooperate. The authorities are arguing that there isn't a breach of the duty and there is no duty to agree. And again, we'll see how that plays out. Sevenoaks, more interesting, because it will come now to a matter for the High Court to adjudicate on. It's, in one sense, it's a matter of regret, I would have thought, that it took so long in terms of that examination for the inspector to decide that the duty to cooperate had not been met. The plan had been submitted earlier in April 2019, but it wasn't until effectively the end of October, after a hearing sessions, that the inspector decided that she didn't think the duty had been satisfied, and that was subject of vociferous correspondence with the authority, culminating in them saying, okay, you go ahead and write us a report saying that we've not complied with the duty, and we'll challenge that in the courts. They've been given permission to bring that judicial review, so that we await developments. So we will see whether they can succeed in showing that the inspector had either misunderstood the duty or hadn't properly exercised her planning judgments in accordance with the guidance relevant to the duty. But that's the context, and the duty to cooperate really is therefore a problem, which is why it behoves us to think big, which is what Ashley's now going to tell us about, where we see the other side of the coin and the problems where local authorities have tried to think big.
Thank you, Michael. Good morning, everybody. Just to pick up on one thing you said, Michael, about Wealden local plan examination I was involved with Wolf Bond, particularly unfortunate failure to cooperate with Eastbourne, as Eastbourne only has Wealden or the sea as its adjoining areas. And in that case, that sad breakdown of cooperation in that case really did have very significant implications for Eastbourne and its unmet need. So my job today is to talk through failures are probably the wrong word, but cases where things have become suboptimal in terms of joint working. And I've picked 3 examples, one relating to the justification for the strategy, one relating to the deliverability of the strategy, and one relating to our old friend, politics. So the first one then relates to the West of England Joint Spatial Plan. And this is a plan that covers Bristol, the urban area, Bath and North East Somerset and South Gloucestershire. Anybody familiar with Bristol and that part of the world and that housing market will know the real driver for this spatial plan is because Bristol has experienced rapid and sustained population growth and has limited capacity to meet that within its urban area or the constrained areas of green belts that adjoin it. The main issue for the failure was this justification which underpinned 12 strategic development locations and the effectiveness of the high-level strategy which the spatial plan sought to provide as a framework. And in particular, there were 2 key points that the inspectors found. First of all, that the 12 development locations had not been adopted against reasonable alternatives on a robust, consistent and objective basis. So it fell at the first hurdle, as it were, and that the inspectors found that the combined authority had been hamstrung by promoting the sites without being open to considering them against other alternatives in a consistent way. And secondly, and quite importantly, for monitoring and implementation purposes of the spatial strategy and the plans that would come forward beneath it, the general housing requirement of 17,000 dwellings was not translated into a requirement for figures for the individual settlements or for each local planning authority area. And that really is quite a serious practical issue moving forward to monitor the performance of the plan. So a very clear lesson there about how you go about making sure that the spatial high-level document still has enough detail to ensure proper monitoring implementation moving forward. May I have the next slide, please, which I think is the tagline of this sad and troubling period in our lives. The next one relates to the North Essex Authorities Local Plan.
There we are, sorry.
Not particularly exciting, but at least the slide corresponds to what I'm saying. But this related to 4 authorities, Essex County Council, and then Colchester, Tendring and Braintree, promoting a joint plan. And the main issues here were the viability issues that underpinned 2 out of the 3 new garden communities that were to deliver a very large amount of the housing need within the 3 districts. And the inspector found in relation to the Colchester is a nice amalgamation of the 2, Colchester and Braintree borders garden community, that the 40% contingency allowance for transport and utilities infrastructure, if that was built in, that would mean that the land price would not be achievable and viable. And in a similar story for west of Braintree, the inspector found that it was at or below the financial viability that the model suggested, and that was contrary to the advice within the PPG. He also found in relation to the west of Braintree garden community that the rapid transport system that was critical for linking the new garden community with Braintree to the east and public transport links was not deliverable. So that brought it into conflict with the MPPF policies on sustainable locations for significant development. He did, in a bit of happy news for those joint authorities at least, find the Tendring and Colchester borders garden community to be very strong in terms of its financial viability. And he found that the 40% contingency that had been allowed there would still enable a competitive land price, but leave enough sufficient headroom to allow for additional costs that may arise. So that's all about the figures and making sure that you invest early on in making sure that there's both sufficient contingency for these very large projects which involve very large amounts of infrastructure on the one hand, but also ensuring that that all tallies up to making sure that there is then a viable and realistic land price that can be achieved. May I have the next slide, please? This different part of the world now, up in the northwest, Greater Manchester Spatial Framework, and the main issue here really is politics, it seems. This document was first published in its initial form in January. There was an expected examination early on this year with anticipated adoption late this year, early next year, but we are currently awaiting a third draft for consultation because it has proved very unpopular to identify locations for meeting the large scale of growth that the spatial framework seeks to achieve. And this has had a very real practical knock-on effect for the local planning authorities covered within the spatial framework, because in many cases they've been holding back their plans, seeking to dovetail with the spatial framework, and because that's stalled, those authorities are now finding it difficult to get on top of their plan making to ensure that they have an up-to-date plan. So that's an unfortunate example of a bold vision and a brave political vision, but it's been hamstrung rather by the realities and contact with public consultation. So a third draft awaited and consultation that will follow on that. So a little while before examination and adoption. I think that then brings us on to the exciting world of statements of common ground.
Do we not want to?
No, sorry, it brings on to success stories. I was too gloomy. You cheer us all up with something exciting and successful.
Yes, okay. So, yeah, I think, I say, continuing our alternating approach to these things. Perhaps just 2 points, because as some people may know, I had the pleasure of participating in part of the North Essex examination, the more recent stages rather than the earlier stages. But perhaps one of the points that's just worth stressing there, obviously, I mean, clearly it's an ongoing examination, so I'm not going to say too much about that, but it is worth stressing that that examination was proceeding under the 2012 version of the MPPF and its associated PPG, as opposed to under the current 2019 MPPF and its associated PPG. There are various differences between the two, but particularly in relation to the PPG advice of planning for infrastructure for those kind of longer term development strategies where you're looking far into the future. It's probably fair to say that the current version of the PPG is more amenable to not trying to, in a sense, tie down every last issue and question about delivery of infrastructure, delivery of the final outcomes at too early a stage, recognizing that in reality, some things aren't going to be possible to be settled at the plan making stage. What's important is engagement with the people who are responsible for the provision of what's needed. So statements of common ground are very, very important to ensuring that the responsible bodies have understood what's needed, even if they can't at that stage say how it's going to be funded or show that it's actually clearly costed and viable, because certain elements are still at large. So that is a point worth bearing in mind, certainly for people obviously plan making now, because that plan making now will be under the 2019 MPPF rather than under the 2012 version. But moving back to the success stories, and I've just picked on 3 for the purposes of illustration. Obviously, it's worth you looking at the various inspectors' reports in relation to these for more detail of the sort of problems and how they were resolved. South Worcestershire, we're going back in time a little, it was adopted in 2016. It was submitted as a plan in 2013, but even to get to submission, there had been quite a lot of preliminary working. There was effectively a predecessor version of what became the South Worcestershire development plan, which didn't actually get to submission. And then we had the submitted plan. Then we had an inspector, incidentally, the same inspector who dealt with the North Essex local plan, Roger Clues, dealt with the examination of the South Worcestershire development plan, and similarly he had a stage 1 and a stage 2 to his examination, and it looked certainly at the end of the stage 1 of the South Worcestershire examination as if that plan might be irredeemably flawed and unable to proceed because of the problems that he identified with how the original housing requirement had been settled and then provisioned. However, he took a pragmatic approach and through the use of main modifications was able to address those inadequacies. What's also quite interesting and comes out of South Worcestershire is an illustration picking up on Ashley's point about politics. The three authorities concerned, Worcester City, Wychavon and Malvern Hills, you had what is not actually uncommon in kind of local government organisation as we have it at the moment. You have an urban area, the city of Worcester, tightly confined to the urban area. Indeed, some parts of what are obviously the built-up area lie outside of Worcester City's administrative area and lie in its adjacent districts. For many years, the City Council being the subject of political control by the Labour administrations, whereas the outside, as it were, that tight boundary, the more rural Wychavon and Malvern Hills, predominantly Conservative administrations, and in a sense, as it were, a different political mindset at play. But nonetheless, when dealing with their respective needs and the unmet needs of Worcester, which could realistically only be met by development outside of Worcester, those authorities were successfully able to come together and to work through their various competing issues and needs and come up with positive solutions. So I say that's a success story, and it's also, I say, notable as a success story because it worked across the political divides and shows that it can be done. And I say those of you who've been looking elsewhere around the country might note a compare and contrast with experience in Luton and central Bedfordshire, about which I say no more. Again, that is an ongoing battle which continues. Then the second example, Gloucester, Cheltenham and Tewkesbury, in one sense somewhat similar. You've got two urban locations, Cheltenham and Gloucester, and then the surrounding rural district of Tewkesbury, obviously not forgetting the important town of Tewkesbury itself. Not quite such a long gestation, albeit the plan was adopted in 2017, submitted in 2014, and because of that duration, one of the issues that the inspectors found was that the housing requirement and different versions of the household projections and so on during the gestation period meant that two of the three local planning authorities would have to embark on an immediate review of their housing provision in order for that plan to be adopted. But that was clearly thought to be a preferable pragmatic outcome to effectively not having that plan in place and then requiring all matters to start afresh. So clearly there were challenges there, and you could say that the ultimate outcome was suboptimal in the sense that two of the authorities would still have to review their plans, but nonetheless a success story. Then the more recent example, Plymouth and South West Devon joint local plan. The three authorities, the City Council, West Devon Borough Council and the South Hams District Council. And again, you've got that similar sort of thing you've got there, but clearly in terms of scale, much more so than the Worcester example. You know, the city of Plymouth, a very large, effectively conurbation, and then surrounded by the two rural districts, and with their own particular high environmental qualities. And what they had been doing in terms of their evolution of their plan making is each of them were preparing to go it alone with 3 separate local plans. And it was the duty to cooperate engagement that those authorities undertook with each other for their own purposes, which highlighted effectively the scale of the strategic cross-boundary issues they were facing, and pointed them to the direction, as specifically obviously with housing as a reference point, pointed them to the direction that realistically, to meet the needs in an effective manner, a bigger spatial picture was needed, and so a joint local plan was the right solution, with the identification of what they called a Plymouth policy area, which you might say was Greater Plymouth, i.e. not limited to the City Council's administrative boundary, but including, as it were, areas within its obvious sphere of influence in the 2 adjacent rural districts, and then, as it were, outside of that Plymouth policy area, a wider policy area for the rural hinterland and the market towns, and so on. And urban extensions associated with Plymouth, and also a new community at Sherford. And again, a success story showing that it is possible to plan big, to plan for a new community. I know there are various issues that people would raise about delivery on the ground after the event, but the point being that it is possible to take that kind of ambition through the plan making process with the right approach, and in that case, obviously inspectors that were pragmatic and able to assist in that. So I think, you know, the key messages are, you do need to start early, you do need to prepare for, as it were, rocks on the road, and you do, above all, need a pragmatic inspector who is prepared to see the big picture and to assist in coming up with solutions. And inevitably there will be problems that will need solutions along the way. So those are the success stories, and now Ashley, who's been champing at the bit, can tell us about how you can capture or maximise your chances of success through the use of the statements of common ground.
Yes, thank you very much, Michael. Drawing it all together then, and the policy solution to this, or a key part of the policy solution, is a statement of common ground. The framework now says at paragraph 27 that you should produce a statement of common ground to document cross-boundary matters and progress towards cooperating to address them. It should be a publicly available document, of course, and the framework sees it as critical to demonstrating the effectiveness of the plan, but also a critical element of discharging the duty to cooperate, on which Michael spoke earlier. There's greater detail in the PPG, in the plan making section, paragraphs 10 to 17, and it tells us that it should be ideally a single document, and it should cover a number of things, all contained within the PPG there, but just in headline points. It should show the justification for the geographical scope of the plan, so that would be looking at the issues that Michael and I have been discussing, various political and social and economic drivers for why you might want to come together for a wider geographical area beyond just the planning authority's 4 corners. It should address the key strategic matters that are being covered. It should explain the responsible plan making authorities and the governance arrangements. So at the very least, the requirements to keep the statements of common ground up to date and under continuous review. It should set out the housing requirements and the distribution of needs. It should look at the capacity to meet plan making authorities' own needs, the extent of then the unmet need, where there's areas of constraint, and the agreements, and perhaps more importantly, the disagreements about the comparative capacity to meet needs within various the relevant planning authorities concerned. And it should, as all good statements of common ground, identify all the issues where agreement has been reached and where it hasn't. There's also further guidance in the PPG. It tells us that these statements of common ground will have to also include how cross-boundary matters were identified in the initial phase, how joint research was produced and commissioned to address those cross-boundary matters, how the impact of emerging policies was assessed, and how development has been coordinated to meet cross-boundary issues. And the PPG gives the express example here that considering those things may drive you to the conclusion that it is appropriate to have a joint strategy as the correct planning response. When you've sat down and thought about those issues early, you may feel that the best way to coordinate development is through a joint strategy, or it gives the other alternative of agreeing strategic policies, so there's a commonality of a strategic approach throughout plans within the affected planning authority's area. So that's the policy basis for statements of common ground and the PPG guidance on what they ought to include.
Thank you, Ashley. Right. I'll just say a couple of things before we move on. First of all, I think in the chat box, I've been told that for data protection reasons, I shouldn't identify who anybody is in relation to this, but in the chat box, those of you who look in the chat box will see there's a very helpful offer from a person associated with an authority somewhere in the southwest of England, offering to share experiences about the ways in which they successfully achieved their outcome. I don't need to say anything more about that, but it's a very kind offer, and I'm sure that some of you will want to take that up. And the second point is, and I think some people have already started doing this, there is a Q&A function. We've obviously had some questions from people already when you registered, but do feel free if you've got a moment to add further questions. I see there are some further questions coming in, and we'll try to pick up on as many of those as we can in the time that we've got. So then just moving on, in terms of the next position, this we take very quickly because I'm afraid it is an empty page so far as any thing from MHCLG is concerned. We've referred to it as the planning policy paper because there seems to be some question mark about the status of what is coming down the line. We know that earlier this year in the precursor Planning for the Future publication, MHCLG had referred to an intention to publish a planning white paper which would emerge in spring 2020. And obviously the traditional role of a white paper is it's gone beyond the green paper consultation stage. It's setting out specific government proposals, and primarily it's setting out proposals which are to be enacted through legislative change, and it's a precursor to that legislative change. Subsequently, as of last week's Treasury statement and its associated documents, we're now told that the latest references to what is said to be a planning policy paper, which isn't quite a creature that we've seen before in that context. And so there is a question mark as to what we're going to get. Is it still going to be, in a sense, work in progress leading up to a white paper and then leading to legislation? Or is it something which will be new to us, in a sense, recognition that there are many changes you can make to the planning system through the issuance of policy and guidance, which don't themselves require legislative change, I mean, I am purely illustrating the point in a sense by an example which it might be said is unlikely to feature, but as a point of fact, if the government decided that it no longer wanted to trouble with the green belt because it was too much of a break on an agenda of build, 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 it wouldn't need any legislation, because the green belt, with the exception of that limited area that's subject to the 1938 London and Home Counties Act, which is effectively a piece of private law, but with that apart, the green belt is wholly a creature of government policy, and it wouldn't really be a matter for legislation if the government decided that it didn't want any green belt. But I said we don't know quite what we're going to get. Also, we don't quite know what the timescale is. I know it's been said by the Treasury that it will emerge in July of 2020, and that obviously coincides with the end of the parliamentary session, which I think is next week. And clearly there's a good sense, if there is going to be a paper proposing reforms, for it to emerge while Parliament is still in sitting, so that it can be announced to Parliament, and then people can take it away to consider over the summer. But in a sense, there is an element to which government time periods are not quite the same as everybody else's time periods, and what is spring becomes stretched, and what is July could possibly become stretched, but we will see. And then what might it say? Well, I'm sure you've all read the planning press as much as I have, and indeed some of the national press in terms of the more wider media outlets. We've heard a lot about reforms and zoning. We've heard quite a lot about extended permitted development beyond what we've already been told about, town centre use classes and so on. I don't know, but I say mischievously, part of me went back to my bookshelves and I found this sitting on one of my shelves. It is from a document, and no prizes for guessing the age. Here we have zoning in operation. It's before the Second World War, so those commentators who've been told that the government is thinking about something more radical than we've seen since the 1948 Act, well, we could go back to 1943 and see how zoning works in practice through the then County of London plan. But I think if we now move on to our questions, so if we pick up on some of the questions that we had earlier on, a number of the questions that people raised did touch very much on duty to cooperate issues and the problems. Well, we sort of rehearsed, I think, quite a lot of the issues in relation to that. I mean, I think the key message that comes out of the inspector's decisions is that authorities have got to, in a sense, ask themselves the hard questions early on, and not just rely on a fact of, well, if we say we're going to meet all our needs in our district and you all say you're going to meet all your needs in your districts, there we are, we've all done everything we need and we've complied with the duty to cooperate. I think that isn't rigorous enough, and you do need to ask yourselves, particularly those of you who are looking at greenbelt releases, to make sure that you can demonstrate that there really is an exceptional circumstance to justify a greenbelt release, and that does mean engaging with your neighbours about what they could do to assist you, even if they themselves may be a greenbelt authority, because not all greenbelt authorities are, as it were, all of their land is greenbelt, and not all of them will have greenbelt which is of the same value as others. So that is an important point, that you do need to grapple with the questions. And affordable housing is an example. Unmet needs, it's not good enough in a sense just to say, well, we've done what we can. You do need to ask, well, could you do more, or could your neighbours do more to assist? Say Luton and Central Beds is another example of that. So I think one of the points that came out is a question as to explaining how the duty to cooperate works to members, and I think that it is a genuine issue and a genuine challenge. It does mean, in a sense, a degree of selflessness by each authority, and actually being prepared to recognise that your authority might need to meet needs that serve another authority's requirements, and that can be challenging. I do recall many years ago doing a case not involving the duty to cooperate, involving development of cemeteries, where Hull wanted to build a cemetery to meet the needs of the citizens of Hull, but to build it in the East Riding. And the political opposition that came from the members of the East Riding Council was vociferous, that they didn't want to see Hull expand, and they certainly didn't want Hull's corpses to be buried in their East Riding, because this was, as it were, boundary reorganisation by stealth. I mean, I sort of slightly exaggerate the point, but certainly there are strong feelings and strong political feelings, and I think as officers, it's officers' responsibility to ensure that their members do engage with the planning issues and not, in a sense, get sidetracked into turf wars and what you might call political issues. There was a question, Ashley, if I think it might be a question I could ask you to comment on. It goes back to the statements of common ground issue. And in terms of ensuring that, I think the question was put in terms of, is there any particular advice on statements of common ground, particularly the point about one overarching statement of common ground, which is what the PPG advises. And the questioner makes the sensible point that when you've got a number of people to engage with, that may very well be challenging. And wouldn't it be, as it were, pragmatically better to have different negotiations on different statements of common ground, some of which are going to be easier to agree than others? Any thoughts on that, Ashley?
Well, I think it's important to remember, as always, that PPG is guidance. I think it is a sensible ambition to try and include everything within a single document, not least because it makes it accessible for members of the public who are seeking to participate in a meaningful way in the examination. If they've got to go and look at lots of different documents, that can present a barrier to effective public engagement. But as you say, or as the questioner says, on the other hand, it may be sometimes appropriate to have discrete topic-specific statements of common ground. I'm thinking sort of self-contained areas like highways or air quality, where they turn on highly technical matters, and it might be better to get those things agreed. And the sooner they are agreed, then perhaps the sooner some of the larger, more thorny strategic issues can also start to be agreed. So I think the advice would be to start off with the ambition of a single one, but if it's proving to be very time consuming and a barrier to agreeing quite important issues, then perhaps it is a good idea to hive off some of the more technical issues into topic specific statements. Yeah,
thank you. Yes, and then we've had some questions coming in this morning, some of which also picked up on points in the earlier questions. One in terms of the role of legislative reform, possibly going back to structure plans, possibly changing the 2012 regulations. I have to say my feeling is that since the track record shows that the system that we have at the moment does enable joint strategic plans to be produced. It does enable them to be successfully adopted using the tools that we've already got. And it seems to me that wanting the government to provide a more bespoke route is unlikely to be something that's going to be high on their agenda, particularly if it requires legislative reform. And I think, obviously one never knows, but I think it's better to think about working with the tools that we've already got. I don't see in this respect that the 2012 regulations pose a problem to successful joint planning. And again, I think the experience of those authorities that we've been referring to have achieved a result would tend to show that. I think there was a question from this morning about using a non-statutory joint planning document rather than a statutory joint plan, which raises an interesting point and also one of my bugbears, because I think there is a problem with the 2012 regulations in terms of its definition of what is in Regulation 5 together with Regulation 6, what will be a DPD and therefore have to be prepared as a DPD. And it seems to me that any worthwhile document that the authorities wanted to prepare would inevitably contain policies which would have a subject matter, which would mean that that subject matter meant they had to be DPDs and would have to be prepared as a DPD. And I don't think that there is an available route under the present 2012 regulations to produce a meaningful joint planning document on a non-statutory basis. And were you to do so, you would be very much at risk of being the subject of judicial review challenge by those who weren't happy with the content of the document, because they would say, I think quite rightly, that a document produced by local authorities which sets out effectively either development proposals which they authorities wish to encourage, or development management policies for things they wish to either regulate or discourage. Those are policies which can only be contained in a DPD, and a local authority has no business publishing such policies outside of the plan making system, which obviously allows for third-party engagement, public consultation, and independent scrutiny. So that's what I would say about that. I say we don't need general reform of the regulations, but if anybody from MHCLG is listening and wants to look at regulations 5 and 6 and loosening the definition, particularly to create a better role for supplementary planning guidance, I for one would be very much cheering you on. Then I think clearly the green belt is a challenging issue. There's a number of questions that flag that up as a problem. I don't know, Ashley, whether there's anything generally you want to add as a comment just on the way that authorities should perhaps go about testing whether there is a case for greenbelt release in the context of a number of neighbours and a number of issues.
Yes, certainly. I mean, it depends, I suppose, a bit under which version of the MPPF the plan is being examined, because as we know, the 2018-19 framework is a bit more explicit about what amounts to exceptional circumstances, or should I say it's more prescriptive about what may amount to them than the previous versions. But what is clear from the case law and from practice, a number of inspectors' reports, is that an important dimension to exceptional circumstances is the degree to which you can meet the needs outside the green belt or outside your authority via the duty to cooperate with neighbours who may be less constrained, either because, as you say, Michael, they've got countryside that's beyond the green belt, which isn't obviously subject to the same policy restrictions, or because they have green belt, but it's not performing against the purposes as strongly as the one in the host district. I think the way that's resolved is through, as I mentioned, these statements of common ground, which set out one of the things to look at is whether it's worth commissioning joint research or undertaking joint research between authorities. I think there's great value in doing, if you're dealing with green belts, a multi-district approach to Greenbelt, because that allows decisions about the duty to cooperate to be taken on a consistent basis, rather than you've got 3 authorities who are all within the same market area, but they've all done their own Greenbelt reports, all perhaps on slightly different methodologies, and so it makes it quite difficult for a decision maker to form a judgment about how constrained they are comparatively when you drill down beyond the very high level. So that's a long-winded way of saying that I think the answer to that is to think early on about the kind of research that you need to be doing, either within the authorities or commissioning an external organisation, consultancy, to help take decisions about these sorts of things, because that bears on demonstrating whether exceptional circumstances have been made out in a particular situation to alter a particular Greenbelt boundary.
Thank you, Ashley. And then I think there was a question about whether or not there was a likelihood of us going back to regional planning as a way out of the problems of the duty to cooperate and the difficulties of joint planning under the current regime. I think, in a sense, an element of realpolitik would probably come to play here. I don't think there's any likelihood that we're going to see anything that would ever call itself regional planning, because the present government would not be, I think, attracted to that. We are seeing clearly local authorities joining together, either through producing joint plans or indeed combined authorities coming forward, which is clearly a positive step. I think it is perhaps, again, if one's thinking about how one could change the system to make it work more effectively, a very simple change, albeit that it would require legislation, it seems to me, is to stop the duty to cooperate being a pass-fail duty that can only be passed at the point of submission or failed at the point of submission, so that the inspector, if he concludes that at the point of submission there had not been adequate cooperation, can do nothing other than find a failure of the duty and the plan can't proceed. I have to say, I don't see any practical reason, as opposed to legislative reason, I don't see any practical reason why the duty can't be something that continues during the plan's examination, so that an inspector were empowered, if he thought that there hadn't been adequate cooperation in relation to some particular issue, whether it's unmet needs or whether it's some cross-boundary piece of infrastructure that was required. I don't see any reason why an inspector couldn't require the authorities to go away and do some further work and produce a statement of common ground to his satisfaction as a way of remedying what had been the failure to cooperate hitherto. As I say, it does seem to me that the present format of the duty is very much a blunt instrument. In terms of other matters, let's just see, I think we've got some further comments about Chiltern and whether they were the makers of their own misfortune or whether it was more their neighbours. But I mean, in a sense, the real problem is we know that you've got to engage, and it may be that your neighbours are not at the same stage of plan making as you are. But if that is the case, you've got to ask the difficult questions, even if they're not asking them as of yet. Any final thoughts, Ashley, you wanted to add? Because I think we're just over the 11 o'clock. So anything you wanted to wrap up with?
No, thank you.
No. Well, in that case, I think what I will say is thank you all very much for participating. We hope that you've been given at least some food for thought. Clearly, the slides are very much headlines, but you will find a lot more if you look at the relevant inspectors' reports for the case studies that we've referred to, and hopefully they will give you some good clues as to where the pitfalls are, but also how to successfully resolve matters. So thank you all very much for participating. Thank you for your various questions and comments, and stay safe and enjoy the rest of the day. Thank you.